number 4, Reich v. Belnord Partners. Good afternoon again, Counsel.
Oh, Your Honors, may it please the Court again. My name is Daryl Vernon. I'm here with Yoram Salagi. We're here for the appellants, the tenants.
Now you may request your rebuttal time.
And now, may I have 2 minutes rebuttal?
You may.
And in the prior case, too.
And if I had paid closer attention to appearances of counsel, I would have asked you the McMaster question. So can I start there? You're also here on a certified question. And McMaster, I know, was raised in this appeal. And so I'm wondering how you get by the language there that says, as I read it at least, if there's an intervening new piece of legislation, but the case has come up on a certified question, we can only answer whether the appellate division was correct on the basis of the law as it was at the time that the appellate division decided the case.
So I read McMaster, and I know it's cited in this case, to say that they did not consider the statute on appeal because it was found unconstitutional. That was the reason they didn't find it on appeal. And in the other cases that this Court has decided, meaning post, where they found there was a right to cure even after the case was going on, a serious change. In the Boardwalk case, where it plainly just applied on appeal, and in that case, this Court put it very well. They said, you cannot affirm something in violation of the law. So the law clearly says it applies to pending claims. We have a pending claim, no doubt. It's up on.
Does it matter in McMaster that was a case that was decided on re-argument?
No, I don't.
Thought about that. How about its
I haven't thought about that, but I don't think that would matter. I think the key issue is it still pending? And certainly for purposes of this statute, which says a claim is pending.
In the context of the Robinson case? You're familiar with that?
No, I didn't see that cited in the briefs.
It was the year before. It was a Court of Appeals case, and it was a case where a procedural statute was applied to pending appeals. And I think the two cases may have to be read together for our purposes. They're so close in time in terms of the analysis. But if you're not familiar with it, it's okay.
I apologize.
No,
but I
not a
would
problem.
like to address, I know Your Honor's concerned with repose, and I'm listening and trying to address it and would like to take the opportunity. Landlords do have repose, and to some extent, nobody has repose because statutes changed. So tenants didn't have repose when, for example, there was a point where they couldn't live together if they weren't married, and the laws changed finally. And so there have been serious changes on both sides. And there was a time when tenants couldn't be evicted in luxury deregulation. There was a time tenants couldn't get evicted in owner occupancy under certain grounds, and that expanded. So things do change, but the repose that the landlord has is, A, he only is going to owe the number of years that is up to 6 years. The second is, they don't need records forever. They just need to keep some reasonable records. It doesn't have to be 6 years. It could be 7. As long as they have something, they have repose. The cases we're all talking about, number one, hardly ever happen because I would lose out on so many years of overcharges if I'm bringing a case 10, 20 years later. My proof problems as a tenant would be miserable. So there is repose, and it's not much different than other cases where you sue someone within the deadline, you can only get a certain amount, but a lot of the proof is from things you did years and years ago. I built the elevator 20 years ago and something was wrong with it. So I don't think the repose question is so problematic, and nor do I think it's entirely dispositive of why this statute should apply. I think the key is that the legislature said they wanted to apply, and they did indeed express all about the remedial intent.
The ones I know of, you have a statute of limitations that says a certain number of years from X, you have to bring a claim. What is the X here?
Okay. The X is from, you have to, well, I'm sorry. There never has been an actual deadline by which you have to bring an overcharge claim. The deadline is you just don't get damages for more than X years before you brought the claim. And that now has been plainly codified, but there never was one. We cited Christensen, I think.
Wasn't the last one from the last overcharge?
That's how you calculate.
Right, but if I wasn't overcharging for 4 years under the prior statute, we're done.
Absolutely.
Not true now.
No, it is still true. If you weren't overcharging for 4 years, you don't owe me anything.
Well, 6 now under the new statute.
Sorry,
but
6.
yes.
You still don't owe me anything. The issue I know you're concerned with is now I can go back a little further to try to find a reliable record. But that's a perfectly fair way to deal with it, because if this landlord has no reliable records for 4, 5, 6, 10 years, that's a problem. That shouldn't inure to their benefit. None of the cases we have, the 2 cases I have here, have that problem, or any complaint about
I understand
records.
these arguments to be that they might not have
Yeah.
records because, as far as they knew, under the law, they didn't have to keep records.
But what I mean to say is that in these cases that we have argued to you, none of the owners are complaining that they didn't have the
That
records.
they didn't, but let's go with this
Just
hypothetical.
general, yes.
Let's go
I
with that
understand.
hypothetical.
Yeah, so if they're complaining they didn't
Doesn't
have
that
records.
mean then there's no repose? I think that's part of.
Yes, I understand, but I pointed out earlier that one reason they needed records anyway is that other cases did allow you to go back to prove your regulation, and 2, they should be able to prove their rent. If they didn't
Some
keep
of these
records for 20
cases-
years, sorry.
Counsel, in some of these cases, the landlord, the owners, the buildings changed hands along the way, right? And it seems to me that if you know that you may potentially be liable for overcharges and have to look back a long way to determine what those overcharges were, that if you're buying a building, you're going to require certain records from the prior owner, and if the prior owner doesn't have those records, well, that may affect the price of the building or your calculation whether you're going to buy it. So it's not just a matter of, well, why should we encourage or reward these landlords for not keeping records? I think it's a little more complicated than that, don't you?
Yeah, I do think it is more complicated, but I think in your example that when the buyer didn't get records, he'd pay a lower price.
Well, that's, yeah.
And he'd get something for it, and therefore, the
But
lack
he-
of
but he
repose,
doesn't-
he's compensated for
But he
because
doesn't
he
know
might.
to ask for
Sorry.
my point is, he doesn't know to ask for those records or negotiate the price when the law changes on him retroactively.
Well, I don't agree with that, because I think all landlords know these regulations just change all the time. And they've changed for 25 years toward the direction, for the most part, of owners. And before that, they were a little better for tenants. And now they're changing back. And they're changing back in part because they do think there was an imbalance. And they said that in the legislation.
So how
They
does one measure the reasonable expectations in a heavily regulated industry? Because that's what you're arguing.
That is what I'm arguing, yeah.
Yes.
That when you bought the building, your expectation was it's regulated. You might look back to 93 when, there wasn't vacancy deregulation. That might happen again, and it did happen again. So things just
The
change around.
expectation that your liability may be changed retrospectively?
Yes, I do think that's a fair, because it did change in the past. It changed for the better in the past, and they didn't come complain then.
What
and
about
tenants had
the
no
addition
complaint.
of the 2 years versus the 4 years?
I think it's nominal, and I think it's something that was meant to balance this and perhaps maybe create incentive, as Your Honor pointed out, to not overcharge as much, maybe because they thought many overcharges were occurring and the money wasn't being recouped, and/or tenants were moving out in deregulated apartments, so landlords had windfalls in that situation. So I do think there are a lot of reasons that they would come up with the 6 years, and it was their prerogative, and could have
Thank you,
shortened it.
counsel.
There was a time they shortened it, sorry.
Thank you.
Thank you for hearing me.
Counsel?
Good afternoon. Deborah Riegel, together with my colleague Ethan Cohn from the law firm of Rosenberg and Estes for the respondents. I'd like to start with the certified question. I don't think there is any question, and I think there's a reason that Mr. Vernon assiduously stayed away from the certified question. There is no factual dispute that these tenants did not bring their claim within the time frame provided under 213A. It is undisputed in the record. It's what the Supreme Court held. It's what the Appellate Division held. And this is the landlord that did everything it should have done post-Roberts. This landlord registered rents, provided rent-stabilized leases and increased the rents only in accordance with guidelines before retroactivity was determined. Not only did the landlord do that, the landlord put these tenants on notice that they had a potential claim under Roberts. And unlike the tenants in all of the cases you've heard before today.
Are you attempting to argue that the legislature could only pass a retroactive statute to impact bad-behaving landlords, as opposed to correct what it saw as an erroneous stream of rent?
So what I'm suggesting, Your Honor, is twofold. Number one, and Judge Stein alluded to it earlier, this is not a claim revival statute, in my view. And there's no question, notwithstanding Mr. Vernon's argument that there was no statute of limitations, that 213A was a statute of limitations prior to the change in the law. And Coniston only held that there was an exception because they found there was fraud in this case. And in our case, both the Supreme Court and the Appellate Division expressly held that there has been no fraud here. This is a landlord that only deregulated the unit in reliance on the pre-Roberts law and acted immediately to correct its conduct when Roberts was decided. There is nothing in this statute, no language whatsoever, that makes it a claim revival statute. When you look at the language of the Child Victims Act, which was enacted by the very same session of this legislature, same members of the legislature, same legislative bill drafters, the Child Victims Act is drastically different. It specifically says that every civil claim or cause of action is hereby revived, and action thereon may be commenced within a specified time frame. It goes on to say that dismissal of a previous action ordered before the effective date of this section on grounds that such previous action was time-barred shall not be grounds for dismissal of a revival action pursuant to this section. There is nothing close to that in this statute, and Judge Feinman did an exhaustive review in In re World Trade Center of the claim revival statutes that have been held to be claim revival statutes. They all have one singular component. They tell you, we are reviving this claim, and we're reviving it for some period of time because of some extraordinary circumstance.
So if it's not claim revival, what is it?
It's a prospective statute. It does not apply to claims that have already been lost by virtue of the failure to act within the statute of limitations. And
of course, that's not what the legislature said.
Well, because the legislature didn't say it, and because the case
law... They said the opposite, actually, didn't they?
Well, they said it applies to pending...
Taking them at their word, they said it applies to pending claims. Let's assume it applies to these claims, then.
Well, they said it applies to pending claims, and I would suggest...
So the argument, I think you tend to be... I kind of agree with you. I don't think it's a claim revival statute. It's a question of whether these are pending claims and then what evidence applies, I think. I don't think it's a... I think that you're logical. It's a logical argument you're making, but... that doesn't negate, though, the pending claims argument.
Well, when you speak about pending claims...
Assuming they're pending, then, of course, the evidentiary arguments, yeah.
Well,
right.
But when you talk about pending claims, then the question is the distinction between pending claims and pending actions and proceedings.
Okay, it's fine if you want to argue that. I'm sure the other judges want to listen to you, but I've never been impressed by that argument.
Okay.
But I'm only one guy.
But just to clarify, you're saying that this wasn't explicitly made a claim revival statute, but it has that effect. Am I understanding you correctly?
No, I'm saying it is not a claim revival statute, and the argument that counsel is making is to give it the effect of being a claim revival statute, notwithstanding that the legislature didn't do it.
Well, the portion of it that says you can look at records that are older than 4 years and determining what a reasonable rate is, you wouldn't say that's a claim revival statute, right?
I would agree that with respect to a timely asserted rent overcharge claim, that's not a revival statute.
That is, if somebody had filed within 4 years, let's say, and the portion of the statute that then says where we were cabined to 4 years, you can now look indefinitely back to try, you're not claiming that that's...
I think there are other issues with that don't obtain to
But you're
this
not saying
case
that
at
makes
this
it a
procedural.
claim revival statute. That's not your argument.
No, my argument is that with respect to claims that have lapsed by virtue of a statute of limitations that existed at the time the claim was brought, they are not revived by virtue of...
Let me ask this. Is there any other area of the law, statute of limitations limit commencement? We started out today talking about that. Is there any other area of the law that incorporates within it a statute of limitation that limits evidence that you can present from a certain period? His counsel on the other side says, well, okay, you've got an accident case and the car is 10 years old and it was poorly designed, but you brought your action within 3 years of the date of the accident. You can go back and look at the design of the car. All of that proof comes in. There's no question of that. If your elevator fails in this building when you leave there, you can go back 50 years and look and see how the elevator was put together here, one way or the other. Why is this? This is such an unusual limitation. Why is that, and why should the legislature not be able to modify that rule of evidence?
So, in the first instance, it is, respectfully, it's predicated on assumption that there was a timely claim. Mm-hmm. And there's not.
Well, the claim's always going to be timely. It's like we've done, these are rolling claims, they're ongoing. So let's just assume it's within the 4 or 6 years. It doesn't matter to me which one you want to talk about. I want to talk about the look-back period, the evidence that's admissible.
We're not there in this case, Your Honor.
Uh-huh.
This was dismissed on a yeah, motion to dismiss.
Yeah, okay, I thought it wasn't summary judgment.
No,
There was
this
no
was a
summary
pre-answer
judgment. It was all
motion to
pre-answer.
dismiss. There is
Okay.
no evidence in the record, although I would point out to Your Honor that the plaintiffs the appellants, not only pleaded, but moved for summary judgment on their allegation that this unit was previously owner-occupied, in which case the rent they were charged was a first rent, which, under the law, was not susceptible to challenge in the manner they're challenging it. A first rent is not a rent that is an increase over a prior rent, precisely because this unit was temporarily exempt, and appellants not only pleaded it, but moved for summary judgment on that basis. So they have conceded that this was a first rent. and I would point out that unlike the other cases, we have...
So their motion was a motion for summary judgment?
Well, they moved for summary judgment before issue was joined.
All right.
But I would also point out...
I want to make sure I didn't read it wrong. All right, go ahead.
No, they did. They cross-moved against my pre-answer motion to dismiss with a motion for summary judgment, notwithstanding that we hadn't answered. So it's a little procedurally strained. I would also point out that we have 6 years of registrations here. The minute Roberts was decided, my client started registering this unit. In 2010, 2011, 2012, 2013, 2014, 2015, 2016. After all of those years of registrations, the tenants woke up. And they have no explanation, or no reasonable explanation, for why they didn't act at any point like all of the other tenants who you've heard from today did. I find it astonishing that they sat on their rights.
I'm a little confused. How does that affect the case?
Well, it affects the case because the rationale that is advanced for going back farther or for allowing this claim that counsel makes is that this was a bad actor. This landlord was a bad actor. This landlord was no more a bad actor than any other landlord that got caught in the Roberts trap.
Do you understand the HTSPA to apply only to landlords who are quote-unquote bad actors?
No.
I'm not quite sure what you mean by that.
No. The HSTPA applies to landlords who, whether intentionally or mistakenly, overcharge their tenants. There's no dispute about that. But their suggestion is you should allow them to bypass the statute of limitations because they think there was something nefarious going on here. That's their excuse for why the statute of limitations shouldn't apply.
I understood the argument to be that that they want the 2019 changes to apply, not that they should ignore the statute of limitations.
Well, but in applying the 2019 changes in the law, in effect, they're asking you to ignore a statute of limitations that bound them at a time when they could have timely brought their claim. There's no explanation. And I just want to point out one last piece, which is with respect to retrospective application, this court has held that retrospective application with respect to procedural steps in a case is not proper. Where there is a procedural act that has already occurred, as here, a dismissal of the action, retrospective application will not permit this court or any court to look back and review that determination. So with respect to retrospective application on procedural steps, and there's no dispute in the law that statute of limitations is a procedural step, that application has to be prospective only.
Thank you, counsel. Counsel?
Thank you.
Please. Few quick things. I don't make the claim that it's a claim revival. I make a claim that the statute says what it says and that there are claims pending in front of this court because there's a certified question whether we should win or lose, and that's our claim, so it's pending. Second, the renewal, the leases that we were given, number one, as Your Honor said, it doesn't really matter under the HSTPA what we were given. They have to be examined if they're reliable records. That's best done on remand, but we were not given stabilized leases. We were given a renewal lease based on an unlawfully deregulated lease. And that renewal lease said in it, anew with each renewal, that we're all reserving our rights. The landlord
You say
said...
an unlawfully deregulated lease,
Yep.
why?
Because it was the lease in 2005 that was deregulated and had a deregulated rent. They only then gave us a renewal in 2010 based on that. You can't do that under stabilization. You have to give an initial stabilized lease. You have to give riders that say how you calculated the rent. They did nothing of the sort. They gave a rider that said, we did a good faith calculation. They've never said what it was because...
So you're disputing her contention that because it was owner occupied, it was exempt, and this is a first rent?
Oh, yeah, we're disputing that. Well, we said there was no such thing was said. We said on information and belief, the prior tenant was maybe an owner, but then we put the records in, which are in the record before the court, and they show it was, for the most part, not registered for some 20 years, and at times registered as exempt with no explanation. So we say that on remand, it's just up to them. They want to prove some wonderful, reliable record, they can do that. But those renewals each said, we're not even sure you're stabilized. We'll adjust the rent if we're required to do so. So they were saying to us that they were not taking repose, as Your Honor puts it, in these renewals. They were not saying anything like that. They were saying, we're all waiting to see. Gersten has to be decided on retroactivity, and then we're going to see. Then Gersten was decided, and they still gave us very similar renewals saying, we're still not sure, we're not sure you're stabilized. When we finally sued them was when in 2016 they gave us a renewal saying, now you're stabilized, here's your rent, but we're going to deregulate you in 3 months because the J51 is going to expire. Sorry we didn't attach all the riders and tell you about that, which was required. That's when the case was brought, and that's why it took time. And on a 3211 motion, none of this could come out. We certainly submit that 3211 was entirely an appropriate way to deal with this case when we made sufficient allegations, and for sure under the HSTPA, we have a valid claim.
Thank you, counsel.
Thank you for hearing me.